administrative law process. And that is one thing that they have focused on, is they've said, look, we think that your hearing examiner was too close to these scientists. In fact, they found an email that was passed on to Professor Mizell. She didn't ask for it or anything, it was just passed on to her from a water board employee, not me, but
They fought about that for years.
They did, and they said, look, they call it ex parte communication, and what that means is, when you have a judge, they're not supposed to be secretly meeting with one side or the other of a dispute. They're supposed to be impartial, only talk to the people in the courtroom, or when everyone's present, and that's just part of our judicial process. That's the protection, the legal protection that we have. And they said, look, the hearing examiner, she's having secret communications, and we think that means she's biased, and we want all her decisions overruled. And we said, oh, no, that wasn't that big of a deal. That issue alone has already been to the Supreme Court and come back. And so that's part of a long, just that one thing, just one email. And so the Supreme Court said, no, we're not going to make them redo everything. We're going to we're going to make the water board disclose that email to everyone, let them respond to that email. All the parties get to have a say and respond to that email, just like they get to respond to every other piece of evidence. And then we're going to let the process go forward. And so that's what happened. And they still weren't happy. They're still not happy about that. So we're still fighting with that in front of the Supreme Court again. So that's where we're at. Like, we have filed every filing they're probably going to allow us to file. We've done every brief we're allowed to brief, and now we just have to wait until there's a decision. I have great confidence in the work that has been done, not by me, but by the people that came before me. I think because our intent was honorable, because we have shown our work and done everything we're supposed to do, I have great confidence that the Supreme Court is going to recognize that, and recognize that the Water Resources Board, they're the ones that are responsible for dealing with these issues. They've done their job, and they're going to honor that. That's all we can do right now, is just hope that this thing is finally solved for once and for all. That's all I have to say.
Yeah,
Sorry about that.
I agree with 99.99% of everything they said.
give us that little bit you don't.
No, I guess, Amy, you've been with us still the longest. Were you up at the Capitol when they passed 288?
I was.
Okay, well, you remember 288 started out, was it Gum? I guess it's J. Paul Gum that introduced it. And it was, and then it had a sister bill on the other side, which is House Bill 1083 with
Was it 1083 Rome?
Roan and Hilliard, I think, and they're both basically the same language in them, but these bills started out, I think they were filed, all the bills were filed in Oklahoma were filed the last, 2 weeks in January, and this was in 06 or 03?
03.
03, okay. Anyway, when these bills were filed, they affected the whole state. They were going to put a moratorium on all the temporary permits issued and submitting temporary permits statewide until the water board got rules together, promulgated, is that the word?
Yes.
And promulgated rules to protect to issue permits that would protect the surface water of the states. And this was the first attempt of conjunctive use or stab at it. And of course the Capitol was full.
Everybody came unglued on that one.
Yeah. We had the irrigators from out west. We had the city of Enid. Remember, everybody in the dog was up there, and that lasted until about 2 months, about the middle of March, and the Capitol was empty. Everybody went home. And Bill 288 was changed where it just affected Arbuckle Simpson, which actually started out as a general law, and it was a special law. It only affected this, and it has still only affected Arbuckle Simpson and
Well, the way around the special law was that it affected all sole source aquifers in the state.
Yeah, well.
That's how they got around the special law provision, because that was a big concern. I remember that.
Anyway, well, back to the Arbuckle Simpson, the few, the 5 or 6 that were left up there, everybody else left. Talking to their local representatives, senators, and House members, and held it off where they pretty well, them and other people around the state, and it is just like ever deals, is along party lines mostly on the thing. Anyway, it was held off until the first part of May, and Senator Gum got the votes and ran it, and then the next day or two, Hillary ran it in the House, and it passed on party lines. And but what that in effect did, on a special law, you're supposed to, I think it's run public notice in the newspaper in the area for 4 weeks, isn't it? I think it is.
For special law, yeah.
Yeah, for special law for 4 weeks, and give proof to the Attorney General that you did that. And there was still time to do it. This was in March, and the session's usually over the middle to the last part of May. They could have still done it and let the people know over the aquifer that they were about to be singled out with this new set of rules of conjunctive use of actually taking private property and subsidizing the springs and streams that belong to the state. And but they wouldn't do that, and we said, well, run it again next year and do it the right way.
It wasn't a special law, though. They didn't have to do it.
Well, like I say.
No, it wasn't. I mean, it was not. Originally,
How
it
wasn't
was.
it a special
When
law?
it said Arbuckle Simpson Aquifer, then it would have been a special law because it would only affect the Arbuckle. When they
Sole
changed
source
it,
aquifer at the time of this act.
doesn't matter. Doesn't matter. Every sole source aquifer in the state. That's how they got around the special
Okay,
law
and
provision.
that's why we could have settled this thing probably 10 years ago. It was just rammed right down all the landowners' throats. And when it could have been done the right way, there was no provision of there were a lot of things he talked about that you didn't know anything about the flow, how you gauged it. There was nothing said about the surface water that we were protecting over the aquifer. There was no restrictions on that. Yeah, you're right. It was appealed, and the Supreme Court said, well, everyone was treated equally within the aquifer, and I mean that was it, thing. But it only affected it would be like.
There's a push to have some other aquifers in the state. I keep hearing Rush Springs.
I'm talking about
designated.
in 03, when this all happened. And Senate Bill 288 was passed, it was appealed, it was there. He is doing his job exactly what 288 told him to do. She was doing her job. Everybody was doing their job. It was completely legal, everything they were doing. They did a good job doing it all. All I'm doing is saying that we were the only ones affected, still are the only ones affected, and the rules weren't even there. Surface water we were protecting. There's no rules saying that there's 25% reduction in the use of the stream water. You've got the city of Ada taking 5,000 acre feet on a provisional
You're right.
permit every year.
Right.
You've got other cities that have applied for up to 10 acre feet of water out of rivers that are
We got mining
protected,
operations pulling it out like nobody's business.
that protecting it. The groundwater people are protecting it. It's wide open on one end and regulated on the other end.
I like to think of it as a holistic approach. And one thing I will know, because you will, if you go back and read about the Arbuckle, there was a lot of insinuation that the landowners that were initially moving their water up to Canadian County, selling water, that they were breaking the law. There was some, I did hear that initially. I mean, you heard that.
Well, yeah,
A bunch
but that was
of- bunch of-
completely legal.
And
Everything was
I'm telling
completely
you,
legal.
it was all legal.
The minute the person.
That's why we had to change, that's why we got the law changed, because it was legal for them to do exactly what they were planning to do.
But there's
And,
a right way to do a law, and you can ram one through.
and we did
I agree
it with
with
pride,
you.
baby.
I thought from the early on, there was a discrepancy. You know, you couldn't you're restricted on how much groundwater you would draw, but not restricted on
We
how much
gotta do
surface
something.
water.
Now, I can't go put a pipe in my river and pump it because I've got a downstream user who has an older permit, so I am restricted.
But you are.
So don't
Get back to the
insinuate
law.
that I can go,
If you lived in a neighborhood.
I'm
And they
absolutely
singled your
restricted on what I
neighborhood
do.
out and passed the law and on just your neighborhood, and the rest of the town or the rest of the state didn't have that.
And if 90% of those neighbors were there okay with that, then that's the majority rule. I mean, we got it passed. We got it
Yeah.
passed, and we got, we
The
did a
Supreme
lot of
Court
hard work.
really has gone both different ways on special laws. We just had a
It's not
tobacco
a
law that
special.
was knocked out.
Special law is a legal term, correct? And this does not qualify as a special law.
That ruling of the.
That was
of
appealed,
the-
it does not qualify as a
like I say,
special law.
They've done prescription drugs that were special laws and got them back on the shelves. They've done smoking deals. I mean, you're the lawyer, but they go either way. Ours was one way, and there's been other rulings by the Supreme Court they've gotten away with it on the thing. It's not consistent. The Supreme Court hadn't been consistent on special law, but when there was even a doubt, why, and I'm not blaming anybody here or anything. It's the politicians. They had the votes to do it, and they did it.
We worked hard to do it.
And
We were
yeah, you
very-
worked hard.
very hard to do it.
There was a lot of senators and House members that didn't think it was right. and
No, and they voted
wanted
against
to-
it.
yeah.
But we worked hard. I mean, we worked very hard. And that you can't understate how hard we worked. I mean, when you have a dynamic shift in Oklahoma law, when the water law has been in place forever, was huge. And we take great pride in that. And it was done with a lot of hard work. And the intention of doing it was because we were concerned about the well-being of those that live down here. That we were all, I mean, I did it for my own special interest too. I
There's
live
a
on the
right way.
Blue
I'm just
River.
saying the procedure.
And we absolutely
There's a
did it the right
to do
way.
stuff. Well, that's
Well,
my
we don't
only thing done. We got to
insinuate
sit here and
don't
argue.
insinuate that we did something
I forgot
wrong.
my white and black referee shirt.
There was
I thought it was my turn to talk, but I guess it's not.
nothing we did was wrong, but don't
You're right.
insinuate that we did something wrong, because we didn't. We did it the way everybody else changes the law. We did it with a lot of hard work, and I do take great offense to the implication that we did something wrong. And that offends me on a very deep level.
But I think that there are views that
Absolutely
perhaps it
there are.
could have been done differently in a way that maybe wouldn't have seemed like it was a special law, even though the Supreme Court ruled.
That it wasn't. But
There still could be
But I
some
like to,
individuals.
I prefer to operate, I mean, there was absolutely no point in my conversation did I point to this gentleman over here and say, you did something wrong, or had you done it the right way? So I do take great exception to the implication that we did something in a back smoky room and were sneaky about it and got it through and
How many votes did it pass by?
it passed by one.
That's what I.
And that's, you know what they call that? A winner. You know what they call that? A winner and a law. And it doesn't matter how many votes we won by. We worked hard to do it. And I do take great exception to the insinuation that we didn't, and that we did something wrong, because we didn't.
I have a question for Mr. Bruce, like if you don't mind, but,
Yeah.
I mean,
I'm better at that. Maybe I can answer something.
I mean, from the government agency side, there are a lot of issues from that people can debate whether this is legal or this is constitutional. There's a guy named Jerry Finn, he's a lawyer, you might have heard of him.
Yeah,
His whole
files on
career-
everything.
His whole career is having statutes and things overturned because they're unconstitutional. I'm in a lawsuit with him right now. But he, you know, the cigarette tax you've all heard about, he was one of the people who got that overturned. You know, these aren't always so clear, and I think Mr. Roos, you know, I mean, I think the point you're trying to make is when there's some gray area, when there's some issue, you know, maybe it would be, I mean, better is if the government agency, the people, and you know, or you know, maybe if there's a gray area, maybe the thing is to do the safe thing and to make sure that you meet every legal requirement that you can. I mean, is that kind of what you're saying? Is like, you know, what you know, if there's even a question about whether it's a special law.
What is a special? What's the definition of a special law?
Well, my understanding is this is an Oklahoma constitutional provision, and if it affects one part of the state, if it doesn't apply equally to all parts of the state,
Yeah.
then it's considered a special law.
Okay, what
And
was
it's-
288 then?
Well, the Supreme Court said.
I know, and they've said other things, they're not real consistent on what they say.
No, they're not.
I will agree to
think-
that.
I mean, I think the result, like certainly, I mean, nobody, I mean, this was if you look at when this law, like what concerns led to the enactment of this law, it was pretty clear, it was Arbuckle-Simpson that the word, those are the people who came up.
Especially for the
Yeah.
Arbuckle, but it started out as a general law.
Yeah.
For 2 months, it was sitting there as a general law.
Everybody.
And everybody came, and they weren't gonna get it passed as
Right.
a general law.
And,
The state said no
Yeah, and
cigar.
I mean, and I think what the Supreme Court said is like, well, you know, at some point the EPA could designate one of these other aquifers, because they pinned it all on the EPA. They said, well, the EPA was the one that pointed at the Arbuckle-Simpson and said, that's a sole source aquifer. There's a one-page
And
document.
everyone in the state of Oklahoma is protected under this law.
There's a one-page document in those thousands of pages that we're in, and that was the one page that from the EPA that said, you know, this is a sole source aquifer, and this is, and there's been a few in the country.
There'll never be another one in Oklahoma, I promise you. They're gun shy.
Yeah, and it
Maybe
has
not
to do
one.
with, is this aquifer, is more than 50% of this aquifer that only for more than 50% of the people there? It's something like that.
Yeah.
You just
That-
did the
It's
Garber
the
Wellington.
main source.
Just
yeah.
did the Garber Wellington. There's a few people up there drinking out of that one too.
That's
So,
true.
I
And
remember
it's not
when-
one.
Yeah.
The language was being worked
Right.
on, and they wanted it to apply to Arbuckle-Simpson, but they couldn't just say
Or it would have been a
Arbuckle-Simpson.
No, they
And
can't.
so,
And
you
then
know,
they
the
have to give
brown
them
one
this
makes it
much, or
special.
we'd have taken,
And
you
as
know,
well
had to
as
give them a
the
little
limestone, I
bit.
went, no, we have
The
limestone.
law said if we pump anything, it's gonna affect the springs and
Of
streams.
course, we've got springs.
But if you
What-
did
what
that-
makes it unique, and that's the only thing we could come up
That would've
with,
been a
that
complete
made it
taking.
unique.
That's why it's not
Oklahoma.
Special.
So,
Yeah, I mean,
it's the only source of aquifer in the law.
like, can you kind of tell me just from your experience and your fellow landowners, like, what, you know, how has this impacted either your future plans or your current use
Well,
compared to like if it had been done? like
say
the other
it was
aquifers?
done and they did it the right way and it passed anyway and everything's fine. Well, was it 3 years now, 4 years?
Mhm.
We still got a rural water district that's not in compliance. We've got City of Ada using the water we're subsidizing springs with, the tune of that 5,000 acre feet a year, which was that 40,000 acres of surface, in other words, we have no market for water. We said, okay, that's fine. Drop it down And Ada said they're gonna need this many thousand acres of water. Rural Water One's gonna need this many, and everything was said. And when the implementation was upheld, there wasn't gonna be any, phasing in time. The head of the board said, y'all have a market for your water now.
Yeah.
Remember when he
But
said that?
that's not been your experience.
And that's not been our experience, because the water board is letting them have it for free. Why pay for it when you can just ride up there and for $125
Yeah.
twice a year, get a permit for 5,000 acre feet of water?
Yeah, I mean,
Why can somebody else go down and get a permit for, what was it for in Tishomingo? 7,000, 10,000?
7,000.
7,000 acre feet of water. You know, there's no, in other words, we're subsidizing it, we have no control over it, or there's no rules for it, for surface water. They operate just like the states.
like when they're
And
in
they're doing nothing wrong. Tishomingo's doing nothing wrong, Ada's doing nothing wrong, Water Board's doing nothing wrong. I'm just saying that,
But there's an
you're talking
inequality.
about the.
There's an inequality.
There's an inequality.
Yeah, there's an inequality there. Nobody's breaking the law. They're doing
So how do they
exactly,
fix that?
I'm sorry?
I was
You
asking
mean the
Jonathan.
compliance part of it?
No, because
Yeah.
it wasn't in the law. The
Well, that
288
was the-
did not tell them they had to do a thing.
No, that would have been in the rules, and I was
Surface
there
water.
when they said, now you have a market.
Uh,
Now we have an agency that has to enforce
Oh.
that market.
288 didn't even have the word surface water in it.
No,
So these guys, they don't have any authority to. We'd have to go back to the Capitol, I guess, and try to get that done, I guess, because I mean,
well, it's there. The requirement is there. It's up to y'all.
I like that when you guys are arguing with each other.
It falls on the water board, right?
Yes, I can say, I
Right?
can say that there's been a very complicated legal history with regards to.
Are you gonna spin your way out?
I am. I'm pivoting, no, I'm just kidding. No, I mean, here, you guys, you may not know that there is another, like, 25, 30-year-old lawsuit involving Birds Mill Spring and
Yes.
Ada that is not over.
because
So,
they haven't gone on, they've
Yeah.
agreed to both
And I-
domestic sand, no, they don't want
Yeah.
that.
I like to
Neither
think
one of them
about-
want
You know, but one of
the.
What would
one
happen
of those
had we-
permits you're talking about that we're not, that we're letting them have is because we don't have a ruling in that.
They have lawyers, they haven't filed it, they haven't
You're
asked for
right, you're right.
They have not asked for it.
Yeah, I think they're happy to.
But where would we be had we not passed 288? I mean, I can tell you where I think I'd be.
Well,
I think I'd be looking for water source. They gotta go, it's their time.
Well, no, I want to leave a little bit of time. I
Okay.
think that this discussion should give you a good perspective that there are all different views. In my opinion, my personal opinion, we have made some really good steps forward towards sustainability. But as you've heard, those steps haven't always been necessarily the most equitable for everybody. So even though we've made some progress, it hasn't been perfect. And there are still policy things that need to be addressed. Landowners, there are some inequalities. Ground owners versus surface water users. There are some inequalities that the law has created that now we're left to wrestle with. So
But it
how-
also
so how
did
do we
create
do that?
some, because my river would not be flowing, my property values would fall. I wouldn't be able to water my cattle on my property if the Blue River goes dry.
Amy, everything's fine, it's all done.
No, but I mean, there are inequalities.
I'm talking about
But that's
today, let's talk
policy.
about today, all that other is done.
We are-
I shouldn't even
there are-
brought up that special law deal.
Inequalities, we have made great steps and there have been protections, but it's not perfect. We haven't gotten to perfect yet, and I don't know that we can get to perfect, but we're gonna try. And I think that should be the goal of any young water professional. And that's what I hope that you guys kind of take with you, is that you can try your hardest to do the right thing, but but it's gonna be messy.
It is messy.
And people aren't always going to be happy with the end result. You're always gonna have somebody, and you've always gotta take that into account, does that make sense? So when you're trying to create policy and trying to work within the confines of the law, it's hard. I mean, I would hate to be in the water board's position. They're getting it from all sides. I think it's kind
I'm
of
the
fitting.
new guy, I mean, come on.
I think it's fitting that Jonathan is in the middle. The water
Why do
board,
you think JD left?
the water board gets it from all sides, you know?
Keep attorneys or directors up there.
None of these opinions are right necessarily. None of them are wrong. Everybody has an interest. Everybody has a position. It's how do you work with all of those interests and positions to create better policy as it relates to water in Oklahoma. That's the goal, and that's what I want you guys to really take from this class. We've got a couple minutes. Does anybody have any questions? No, because I know you've been biting your tongue.
Yeah, well, because it's all policy related, and so that's where I kind of have a question, and I know that each of you are probably going to have a different answer for this question, so I don't know who wants to attempt to take it. But a lot of it is over the language of 288, and so that seems to be the biggest debate between everybody is what the language was. And so my question is what language would eliminate some of the issues within the policy itself?
That's a good question.
I don't know that there would have been any right answer. Because you couldn't say the reduction of the natural flow by this until you had the science. I mean, the science ultimately did drive the answer, so it had to be kind of open like that. Dwayne Smith, who was the head of the waterways for years, he always would, I hear him say, if you follow the Clean Water Act, the Federal Clean Water Act, then you can never flush your toilet. I mean, you are polluting. I mean, so you have to take things in a policy in total.
Right.
So I don't know that it could have been any more defined because we needed the science to provide that definition.
Well, if it had stated you cannot reduce natural flow by, or total flow by 25% or whatever, then that defines it.
The law
But
was
we didn't know what that
not
25% may dry up
That was one of our
Springs.
arguments. We wanted to sit down
We
and
didn't know,
get
no, the flow, if you
it
say
in a law form.
25%
That was a
of
poor law, poorly written
total
law.
flow
It didn't
coming
have-
out of certain.
It did say-
But what did that
It said you
do
can't
to,
do
what did
anything.
fish species, what did it do to the overall system? That's why we waited for the science.
Well, we
to
still-
be able to
no,
look.
I think, but that would have been that would have been a very precise thing, and we still don't know what percent you need.
Yeah.
When you
Yeah.
say, if you
Yeah.
want to protect it this much, then we could have solved that question.
Right.
But a
It
good
may
law
not have
would
been
have,
sustainable.
would have taken care of a lot of stuff.
I mean, to chime in with you, I mean, I think what we'd like to see when we have statutes drafted is we would like statutes that are clear, everyone knows what they mean, so that they know how to act. So Mr. Roos knows, well, this is what I can do in the future, this is what I can invest my money in if I want to operate a certain way, if I want to sell water to this person, this is, I can make my future plans. A law that is a little bit more specific and clear leads to more predictable outcomes. And unpredictable outcomes result in decades of litigation.
Yes.
Sometimes we don't have a camera
We
man. They
couldn't
don't
be
have a
clear
rule book.
because we didn't have the science. We couldn't say.
But we didn't have the target. We never had the target.
I know, but I think that
It's very hard on the OWRP.
But when we were drafting that language, we didn't know what that target needed to be.
Yeah, I just wasn't sure if there were parameters like domestic, cannot have an effect on domestic use, environmental impact, or things like that. I didn't know if there was some language that you could put in there like that might eliminate some of that
If we put
natural
10%,
flow.
we put 5%.
Well, not so much a number, but like an area specifically to look at, because you use fish as a species of something, to see if the stream flow was affected. If you would have provided that maybe in the statute, could that have made it a little bit more limiting for someone to do a hydrological study or something like that on?
But then you get which fish, I mean, it all had to go
Yeah,
back,
right.
on our mind, it all had to go back to the science, and so it was vague by design to allow the science to drive the number.
Right, so precedent happens, so that's what happens is you take it and you make the
But the
legislation,
law
then you have to
said
have
if you took
precedent to
any-
determine
If you
it.
affected any spraying, you couldn't do it.
Right, so that was
So
essentially
it
my
was
question.
It was a flawed deal to begin with.
It's a good question.
Yeah, very good question.
Yeah.
Bobby?
I actually can see Ms. Russo's point, because if you're gonna call it conjunctive management, it seems like one side is more managed than the other side. It's like giving your kids a curfew, they're the same
Your
age.
youngest kid.
But the girl has to be in my team and the boy
I'm a
has to
twin,
be
that happened to me.
What
Well, it's
happened?
not conjunctive.
So that's not conjunctive. Yeah, they both got a curfew, but he gets to lay out all night. You know, it's not the same.
Yeah.
Well, that was one of the ideas behind the rules, was to.
If you're gonna call it conjunctive, you need to be conjunctive.
There should be some
Yes.
limitations on the surface water withdrawals as well.
Yes.
Yeah.
Right, yeah, and there are restrictions on the
Those
surface
permits
water.
were those permits?
They went.
Well, it's all prior appropriation for surface water. I mean, you
Right.
get what you get.
But if it's conjunctive, it shouldn't be.
Well, that's the thing, it wasn't provided
appropriation
for in the
anymore.
statute, so you can't just put it in there and say that it's, you know,
Right. Senate Bill 288 doesn't provide for similar restrictions on
On
It's been
surface
surface.
tough
water.
and expensive on everybody
Yeah.
because of the way it was
That's not
written.
conjunctive.
Right, right.
That's
So-
like a dysfunctional balance.
Conjunction
Balancing
dysfunction,
the
that's
two.
it.
As we're approaching Thanksgiving.
But our ultimate goal was to make sure that the surface flows continue. Because most people in the Arbuckle Simpson rely on the surface flows. They don't pump the groundwater. They rely on the surface flows. We wait for it to come to the surface. It's cheaper, it's easier, and as long as that's flowing.
But if you're on top of the recharge area, like Mr. Ruth
It's not
says,
gonna go.
you don't have the springs
Yeah.
and surface
Spring.
water.
Yeah, right.
So would it help to correlate surface water with groundwater in the same policy?
It would,
That
but you
would
have
be
to change the statute when you.
Because
But
the
then-
reason I ask that,
Before you could-
Yeah.
we have the minor problem, where they're taking, it's affecting Sulphur Springs, right?
It's affecting everything.
The lines,
Yeah.
yeah.
Okay, but that has to do.
Are you talking about our
because-
special project?
Uh-huh.
I don't remember. I don't remember what the
No,
special
not
project is.
necessarily, no. I'm just, because there isn't a policy currently that has surface water in
No,
relation
and then
to
how far have you
groundwater.
reached? Because I use Arbuckle Simpson water, but I live in Bryan County. I live in Durant, but I use Arbuckle Simpson water because it flows right by me.
But I mean,
Plus a
we
little
have a buffer
rainwater,
zone.
plus a little.
That you
do
were
what?
talking about pumping at the wells, you can't within so many,
Yes,
Yes.
but the minors that are affecting, they're outside that buffer zone, but it's still affecting those streams. So how?
Because they can take whatever they're not restricted on what they can remove. Like a well, you gotta go say, you get a permit for X number of acre feet
Yeah.
based on your proportion. The mining operations don't have to do that for the well that they remove. They don't. Come on.
Existing mines. don't.
there's a whole
That's
nother,
another
there's a
law.
whole
That's a
nother.
whole nother special project. Let's talk about that law.
If there was a law that correlated the two together, wouldn't that go into effect for what they currently do?
For mines, depends on
Or
the law.
anybody
I mean,
using groundwater
mostly-
and affecting surface water, basically?
Laws normally aren't retrospective, they're usually prospective. And so it's very difficult, that's why you have the exemption in Senate Bill 597, because you have mines who have invested millions of dollars.
But we had argued that mines were being operated like wells, that there was that provision in the law that,
Well, and for like
Back
this
forever.
situation, you don't have something, you can use your surface rights, but it doesn't, I mean, you have a permit on your groundwater rights.
Right, there aren't any, so there's not many springs or streams that emanate in the recharge areas, which is kind of in the northern part of the Huntington Anaheim, which is where Mr. Reese is located. So he can't wait for the springs to pop up, because they don't pop up on his property, they pop up down in the southern part of the aquifer. So he has to use groundwater, if he's going to. So, the bottom line is, I want you guys to understand Oklahoma water law in general is messy. Oklahoma water law regarding the Arbuckle Simpson Aquifer specifically is even messier. It's all, everyone has an interest. We're all trying to work towards the sustainability, but how we get there, there may be some problems, and you guys have identified a really good one. There's no similar restrictions on surface water use. How is
Other
that?
states do that.
Yeah.
New Mexico.
I have a lot of
Yes.
And, yeah,
Texas is
But
actually
it could be
really.
it could be an easy fix.
surface water and groundwater.
It's just getting us
Really
some
easy
hazards.
fix.
You write it and show me.
Yes, you see what other states do that's good, and then most states look at that and will follow in
Sometimes.
suit.
You would think.
It's not that.
Oscar,
Every state has
Oh,
their
oh, yeah.
Oh, Mr. Grimes, I had one question with new implications. On September 18th, the Osage Nation had a new implication for what?
Are you gonna Good question.
That's why we waited on him.
I didn't say this.
No,
I was
finish your
really
question.
wondering-
Please finish your question.
So I was wondering, what are the new implications with the Oklahoma Water Resources Board with federal tribes who are in the state, considering that tribes are now able to give individuals water permits for drilling rights as long as they're inside of their nation? I know that Principal Chief Standing Bear said that he would work with negotiations with your board. Has he come to the board and had talks?
Yeah, I mean, we've
What are the
had-
new implications that are going to subside from that meeting?
Well, we've had several informal meetings, like they've made their position clear.
Right.
And this is a issue where the federal agency and the state agency have different opinions. I think the underlying dispute, as I understand it, is the Osage Nation, they're really special. Like, they got their land, they bought it. They didn't get a treaty, they just bought it. They also reserved all the mineral rights underneath their property. In some states, water is considered a mineral, and that's their position, is that when they reserve the mineral rights, they intended to reserve the water rights too. The rest of the state, which is our position is that the whole state, groundwater is considered private property. So we want to treat Osage County, at least right now, like we'd like to treat Osage County no different than anybody else. The landowners come to us and get a permit. It's their water, like no matter what, but they come to us, we go through our process, we give them a permit. That's really complicated by tribal rights that are asserted. We just resolved a really long legal battle with Choctaw Nation and Chickasaw Nation, not because we tried it to its completion, but because we just said, let's forget about the courts, let's just meet and hammer out, what do you guys need? This is what we need, this is what you guys need, can we meet somewhere? All the parties to that Chickasaw Choctaw that participated in that settlement were really satisfied and have really been public about how happy they are about the outcome of that. Not always are those resolutions possible, but we're still really early in dealing with this, and we have an innovation transfer application from the city of Enid. They want to take water out of Call Lake, and the Osage Nation has protested that. And so now we're in a position where we have to deal with it.
Are they doing surface water and groundwater within their tribal area? Saying it's all, that section not regulated?
Yeah, the Bureau of
Okay.
Indian Affairs they've gone through these processes of making rules to allow them to issue permits to people in Osage County. And every time they do, someone from the water board will say, hey, wait, we're the ones who are supposed to do that. But we've never come to blows legally or anything. They're not the only tribe in Oklahoma that says the water board doesn't have the right to do it. We hear that. Like, those issues have been around since statehood, and, we think that people need resolution to those issues, but we can only.
Are they following the state guidelines, the state laws, like 2 acre-feet per acre, or are they just?
No.
Not at all.
It's not like that up there. But,
Okay, so
but,
their own rules, okay,
Yeah.
I wasn't sure how far they
Yeah.
were down the road they were going down.
So, to answer your question, we're certainly, I've met Mr. Standing Bear, who's a really nice guy. We really look forward to trying to see what resolution we can come to. If it comes to just a pure legal question, there may be, something that goes to the Oklahoma or the U.S. Supreme Court. Because this is federal, tri-state.
Right.
It might be a federal issue. And so, we'll take that as it comes, but, we certainly recognize that, our state system of water rights only goes so far as the state's power and the state's authority that we received when the state was created. Other types of water rights that come from the federal government, like prior to 1907, we recognize that those are competing claims that we have to resolve. We've been able to with 2 tribes. We have a bunch of other tribes that have similar claims, and we know that those issues are going to arise in the future, and they really arise most of the time when water starts getting scarce, like when there's plans to ship water from one part of the state to another. That's when this stuff boils up, and we have to deal with it. That's what happened with Chickasaws and Choctaws. The Texas wanted to get water. That's what made that. And I think the resolution from that, I think everybody involved would say, hey, that's, not everybody, but most of the parties involved are like, hey, we were able to control the outcome of this ourselves. We were able to meet in the room and agree, and, we have a united front now. That would be, I think, the state would really like to see more of that. But we'll just have to see what happens. Mr. Standing Bear, he has talked to us many times in letters, and so, we'll definitely be talking to him in the future, so.
Well, that was a nice curveball to end.
Sweat on his forehead.
I'm gonna get called into my boss's office.
But that's the way to end it. Arbuckle Simpson could be compacted by tomorrow afternoon, I'll tell you. We've already taken our beating.
Somebody else's turn now.
Yeah, let's make it equitable.
Poor Jonathan, though, the water board's in all of it, so.
Well, and I tell you, when you look at the budget fight that's going on, and let me tell you who's suffering. Those of us that are out here counting on an agency that is so underfunded to be able to do what they have been required to do, and they don't have the staff because they don't have the funding. So the budget matters, and it matters on so many levels, including their ability to do their job. So I'll get off the budget.
Let's do it ourselves. Me and you get along so well.
We all Joe,
We are really buddies. We're not.
you're fine as long as you stick and stay that way.
All right, guys, I appreciate your time. Email me your outlines as quickly as possible if you want me to review them. And otherwise, let's meet in the courtroom